Now let us touch the aspect of GST. GST we think is good night, sweet dreams, take care. But believe me friends, GST is a very big bone of contention. Builder won't speak more, but when it comes to giving possession to you, he will say, now give me GST amount. Same is the case in rental premises going for redevelopment. The area, additional areas, etc., there also it will be a big, huge amount will be there, 5%. Now, how is this 5% amount arrived for GST? That is also a story. GST is actually 7.5%. You will say every time we are looking, it is called 5% and not 7.5%. And what are you talking? GST, goods and service tax. Any property which is being redeveloped involves a land aspect plus construction aspect. On land, they cannot levy GST. So, to cut short their work, what the GST department says, we presume 1/3 is the cost of land, and as abatement out of 7.5%, 1/3, which works out to 2.5%, we are giving you an abatement, and so builders charge 5%. Now, pausing here for a moment, if you look at land, the prices are very high in a city like Bombay. But if you go interior, some 100 kilometers away from Bombay, there the cost of land is peanuts. How can you equate both as same cost of land? He also gets 1/3 abatement and you also get 1/3 abatement. Various high courts of Bombay have taken a view that the policy taken by the GST department is not correct. Gujarat High Court judgment is there, and some from South India, some High Court judgments are there. This saying it is blatantly illegal and that is not the correct stand. But what is the view of the GST department? Very simple. I happen to be, one GST commissioner was my friend, so I casually off the record asked him, yes sir, this is my submissions and these are High Court judgments are there. I request you to advise me because I also got a few flats and which are under redevelopment. So what he told me, Vinod, as far as I am concerned, sitting in a chair, I will recover GST from you. Your point is valid. You pay under protest and go to Supreme Court, get us an order from the Supreme Court and we will accept it. Very simple. Revenue person's approach is very clear. I want GST at 5%. This is my instructions. So if builders lobby devotes some time to correct such anomalies, then the individual flat purchaser stands to gain. But builders lobby is only interested in that thing, what is affecting them. Now as a flat purchaser, even if you are convinced by my submission, the cost of going for this litigation is much more than the 2.5% or whatever, that 7.5% or 5% GST is there. So knowing certain things are wrong, we have to accept it. I'll give one more example. Maharashtra Ownership Flats Act is there for the state of Maharashtra. Each state has got their own Ownership Flats Act. When these enactments were done, Ownership Flats Act, in Maharashtra we got it in the year 1964. Similarly, after independence, all states got their own Independent Ownership Flats Act. At that point of time, RERA was not in existence. So we had individual state acts. Recently, one such petition went to Supreme Court. It was pertaining to West Bengal. It is called Hirwa something. In that petition, Supreme Court has said that this Ownership Flats Act is illegal. And this has to be scrapped. So West Bengal Ownership Flats Act is scrapped. As far as other states acts are concerned, including Maharashtra Ownership Flats Act, it was not operational for a few months. Again it is made operational. Maharashtra Ownership Flats Act, because of the repealing provision, it is a temporary piece of temporary legislation. Every 5 years isko dhakke marte, just as elections come and go. Every now a push is given and it is extended by 5 years. For some time it was not applicable, MOFA, but now again it is applicable because of the amendments. So, as a flat purchaser, I am trying to tell you, the right course for you is to file your complaints in MOFA today before MOFA gets scrapped or repealed. RERA, as we know, in my view, is a toothless act. Reason for the same is, in RERA, they are making it things difficult for the purchasers to ventilate their grievances. They say, you go to the conciliation officer, so another 6 months goes there. And what is the need of conciliation? And presuming you want conciliation, why can't both the proceedings go together? If one day prior to your order, if some compromises occur, you can always file a consentum and get the matter resolved. But the approach, in my view, of the government authorities, RERA, which is an open secret, is they want the project to be completed. They say, ये जो भी बिल्डर ने किया है बराबर नहीं है, वो सब वो बाद में ले लो, पहला प्रोजेक्ट कंप्लीट करने दो. And as we know, builders are smart enough to execute a company, LLP, with a limited liability partnership. The amount that will be there will be peanuts. If you look at some prominent builders, the name is of the prominent builders, but the persons who are the directors of their company, sometimes they are staying at very far off places like Mira Road, Dombivali, Virar, etc. I am not saying that those persons are not up to the mark. What I am trying to make a point is, the brand name is one thing which attracts our eyes, and we expect certain standards when the flat costs are in crores. And the probability is the director of that company's flat might not even be 25% of the cost of the flat which he is selling. So tomorrow, even if that liability is coming, it will come on a person who does not have any money. If you call him like an international fakir, it will not be wrong. Look at brand names which have come, they have declared in today's paper only, I think it is that today or yesterday's paper. The best of the brand names of Bombay, they have said that we are not going to complete the project.